Okay. In terms of business organization strategies, most farms are single entities. Most of them are sole proprietorships, about 70 to 75%. Farming operations utilize the single entity approach, just one entity that has the land and has the operating equipment. But it might make sense in many instances to use multiple entities. So we've got a real estate entity, we've got an operational entity. Real estate entities typically nowadays an LLC, and the operational entity could be just about anything, and then there's a lease. The real estate gets leased over to the operational entity that contains the machinery, maybe the child's land, maybe the parent's land, but those tend to be over here. And so we've got income that's coming this way, we've got the rental real estate that's going that way. And we have different aspects of the family that don't own different parts of the business. So the operational entity, lots of choices for that one, lots of assets that are in there. The landholding entity, you do not want a C Corp, probably a sole proprietorship or an LLC. We just don't want to put real estate in a straightforward C Corp because of that law change in 1986. For heirs not in the business, some of the suggestions here to achieve equitable treatment for them, probably don't want them in the operational side of the business. Maybe you've got two entities, so we don't want the off-farm heirs to have any ownership in the operational side of the business. Those businesses tend not to distribute any income. I mean, how many of you that have small, closely held farming corporations pay a dividend? And some do. Most do not. What do you do with earnings of the business? Just plow it right back in to the business, and that's fine. But the problem comes in, if you've got a minority interest in a small, closely held farming corporation, and they can't control anything because it is a minority interest, and they don't get any distributions out, they're not a farm heir. What do they want? They want income from that. They're going to view that as a dead investment, and it's just going to foster problems. Go to your one handout. And this is just a summary of the first couple of paragraphs of the article. You'll notice here, this is off our website. There is a full PDF that's multiple pages long. This is the one that says Valuing Minority Interests in Closely Held Farming Operations. Okay, I'll get to the common mistakes here in just a moment. This is a disastrous case that came out of Iowa last June.
This was just in the magazine that came in today.
Yep, that's the one, Bauer Farms. Yeah, Dave Repp. Dave Repp is one of the guys that teaches on day 2 of my tax team in Iowa. He was much more kind to the court than I am in my article. I think their decision is absolutely ridiculous. Now, he gets there, but he's just a little softer. I think the magazine edited it down. I did see that. That's in Progressive Farmer. Yeah. And that's the case I'm talking about. My detailed article's on the website. I published it a day or two after the opinion came out. You can see the link on the bottom of this for the full PDF. So you can go to the website and see the whole thing with footnotes. But what happened here was that you had a farming corporation, a C Corp, created in Iowa. This is the disaster case that you want to avoid. Created in 1964 by two brothers. Okay? Two brothers formed the corporation. They each have sons, some of which are interested in farming, some of which are not. One of those sons, by one of the brothers at the time, had just graduated law school, had become a brand new lawyer, and he helped draft the documents that created the corporation. He told his dad at that time, I don't want any stock in this. I'm not going to be part of the farming operation. I don't want any ownership interest in this. I'm going to go off to Des Moines and I'm going to start my law career. And he did. He became very successful and multimillionaire. But his dad gave him some stock. Okay, Dad wanted to be nice, treat all the kids equally, so he gave his lawyer son some stock. Okay, time goes on, and he's a member of the board of directors, and the corporation's not paying any dividends. And come along about 1984, he's still on the board, and he is getting $5,000 a year for being a member of the board. Okay, so he's not getting nothing. He is getting a payment. I'm not sure that that's reflected in the article. It is on my piece, but not in the magazine article. And in 1984, he suggested, well, you know, we need a buy-sell agreement. Now, initially, there was an agreement for a buyout, but it wasn't very good. It was based on stock value established in 1964 at what the land values were then, and it really didn't adjust over time. So it was severely undervaluing the stock. And so he was right. He said, let's have another buy-sell agreement. So he actually drafts the new buy-sell agreement in 1984, which first says, okay, you got to offer your stock back to the corporation, and then they might have to buy it, and there were certain rules to protect the minority interests in this. Well, his dad continues to give him stock over the years to a point in time he's up, and when his dad died in the late 80s, he gets more. He's now got about 24% interest in the corporation. He still can't control anything. His mom died in the early 90s, so within about a 2-year period, his parents are gone. And so it's now his dad's brother, so that'd be his uncle, right? Is that right? I think that's right. I have to draw this stuff out, but I think that's right. His uncle, one of the original founders, that is the controlling shareholder, and actually this guy's brother, who's the day-to-day farm manager. Now, his brother's disabled. But his brother is not disabled enough that he can't run the day-to-day operation from the farm business. Okay, that's his brother. Once his parents are gone, his dad, who is one of the initial co-founders, and now his mom, he starts griping at everybody. Now remember, he's never had anything to do with the farm. He's never committed a day of labor to the farm. He's never put any capital into it. He's never invested anything into it. Nothing. He has nothing on the line here except he's got a 24% stock interest in the corporation. What do you think's happened to land value since 1964? This thing's worth over $10 million now. After his parents are gone, he sends a demand letter over to his cousin, one of the sons of the other brother that was the founder, and said, who's now running the corporation because his dad had died, so the original founders are gone. So he sends a letter to his cousin who's running it, I want bought out. Okay. We'll buy you out. We'll figure out what this is worth. And they figured it out and said, we're going to discount you because it's a 24% interest. You can't control anything. And again, if you were to sell your stock for its value to somebody else, they're not going to pay 24% of what the full corporation's worth. So let's say if the corporation's worth $10 million, they're not going to pay you 2.4. They're going to pay you less because they can't do anything with it. What are your rights as a minority shareholder? Basically to be abused by the majority. Okay. You don't expect to get a dividend in a farm corporation. And he even testified, it's in his deposition testimony, I knew I was never going to get a dividend. I had no expectation I was going to get a dividend. And he even testified in his deposition testimony, well, I'm jumping ahead, he rejected the 2.4 and he just kind of let it sit there for a while. Well, 15 years later, he actually got kicked off the board in the late 90s because now he started blocking decisions that they needed to make. So the board voted him off, said, get out of here. Just go practice law and leave us alone. You've never worked on the farm. You don't have any assets committed to it. You do have 24% interest, but we vote you off. Okay, because they needed to put up some corrals and some buildings, and so therefore, he didn't want them to spend any money. He wanted them to plow it all back into the corporation so that it increased the value of his stock because he knew what he was going to do down the road. He was going to cash out. He gets ready to retire. He gets retirement age. He's done with his law practice career, his legal practice, and here comes another demand letter over to his cousin. Now I want bought out. Now I want much more because the land values have skyrocketed, been going up 15, 20% per year, and he's going to cash out. No discount. They couldn't come to an agreement. He sues, and he said, I've been abused. Abuse of the minority shareholder. You've abused me. You never paid me a dividend. Well, you testified you knew you were never going to get a dividend. How's that abuse? Never mind that. You abused me. And it's abuse because you're arguing that you should discount my stock to reflect its minority interest. I said, well, Bob, you testified at your deposition that when the question was put to you, why don't you just buy the corporation because you're worth multi-millions? Why don't you just buy the whole thing and then liquidate it and bag all the money? No, I don't want to do that. Okay. If you were to, the question was put to him, do you expect that if somebody other than the corporation to buy your stock, that you would be able to sell it for full fair market value? No. They would insist on a discount. Okay, and you don't want us to discount your value? No, I want full fair market value. And failure to pay me full fair market value, a 24% pro rata interest of the now value of the corporation, is abusive. He loses in the trial court, gets to the Iowa Supreme Court, and they reverse. They said he was abused. His reasonable expectations as a minority shareholder were not met. They said he has a reasonable expectation of being paid a dividend. He has a reasonable expectation of his interest not being discounted. Really? They made this thing up out of whole cloth. I mean, this is nuts. Okay? Now, another thing that's in there, some might say, you know, keep in mind, what is this corporation going to have to do to buy him out? Do they have $2.4 million in cool cash laying around? Yeah, we'll buy you out. No. What are they going to have to do? Liquidate some of the land. This land's been in this is not only a century farm, this land's been in the family since statehood. Can you imagine the capital gains tax that's going to have to be paid if they liquidate some of that land? Plus, it's a C Corp. You have 2 layers of tax. Also in his deposition testimony, which the court didn't refer to any of this stuff that I'm talking about. It looks like he's being abused. Then you read his deposition testimony and you read the briefs in the case, and you get a whole different picked and choose the facts that they wanted. They knew the result that they wanted, and they just picked and chose, I'm convinced, the facts that they wanted to get there. You also wonder, well, if this took so long, why wasn't there an S election made so that we could at least avoid 1 layer of tax? When you make an S election, every shareholder has to consent to the election. Well, guess who didn't consent? The minority shareholder. He's stringing them out to dry. So they can't get a discount. They can't get a discount to reflect all the built-in capital gain tax, which the tax court routinely recognizes. All the courts recognize that now. Because he blocked them from making an S election. He's really put a hammer to them. And he's going to cause, if this holds, it's back to the trial court to use the reasonable expectations theory. To the 3rd time, the judge at the trial court level in Winterset, Iowa, has said no twice. Now it's back to him before the Supreme Court for trial. It starts on March 18th. I wouldn't be surprised the 3rd time the same judge, it's before the same judge, he's going to say, I don't care that the Supreme Court said reasonable expectations. I think your reasonable expectations were and should be, you are not going to get fair market value. You're not going to get a dividend. Look at your testimony. You prevented them from avoiding a layer of tax by not consenting to the S election. You did all this. And the judge at the trial court level basically said he was the one that was causing abuse, not the other way around. Read this case. Go to my article on the website. If you get Progressive Farmer, take a look at that. That's a shorter summary of the case that Dave is talking about, David Rep. And this is a case that really points out the problems that can come up. And some of these states recognize this reasonable expectations theory. It's a minority of the states that's out there that recognize this. But if that thing holds, that creates a lot of havoc. Now, I have drafted proposed legislation to come up with a mandatory buy-sell, a statutory buy-sell if you don't have one. Now, the other interesting thing about this is he helped draft that 1984 buy-sell agreement, and then he didn't follow it, and the court never held him to that, which is the other thing that really bothers me about this case. This guy drafted the procedure for a buyout, then ignored it, testified in his deposition testimony that he had forgotten about it, and the court never held his feet to the fire. And this case is so bad on so many points, it's just unbelievable. But read that if you want to have trouble sleeping some night, read this one right before you try to go to bed. This is a nightmare of a case. This is what you want to avoid. A well-crafted buy-sell, and what I'm trying to draft is they had a buy-sell. It wasn't the best. It wasn't followed. But what I'm trying to create is a default buy-sell, kind of like a default will. If you die without a will, the state has a will for you. This is what I'm saying. If you create a farm corporation or a small, closely held corporation, and you don't have a buy-sell, then we're going to give you one so that we avoid these problems. That's what I'm trying to do. And I'm still in the drafting stages. It's not going to happen this session of the legislature in Iowa, but hopefully by the next one. It's a lot of things I got to think about when I draft this. So I'm on about the 5th revision to try to prevent these problems. But that is a nightmare of a case. It's just horrible.
Could they have borrowed money, 24% of the entity, and written off the interest expense and paid it out? Arlington has done that in the past, maybe the same type of thing.
Yeah, but they're not.
Take it right off.
I know. There was some discussion about that. The cost of that was going to be too prohibitive for them. Yeah, it's just, he's created a real mess for him. It's an awful case. It's a tough case. So let me get to the buy-sell issue. Got a lot of transfer issues, Social Security planning, using trusts and we talked about some of this already, and some of these distribution plans in trust. But buy-sells, I think they're critical for nearly every business that's out there. And there are various ways to structure a buy-sell, tax and non-tax reasons, and in terms of the proper way to structure a buy-sell. You got to think about what triggers the buy-sell. You know, divorce is one of those things that you can protect the business from by a well-drafted buy-sell. That can be a triggering event. Death. You know, just when somebody wants to sell their shares, that triggers the buy-sell. And then you got to really, this is a document, I think this is kind of the lifeblood. A buy-sell agreement is really the lifeblood of a small operation. If you got a good buy-sell, that's your transition document. If it's drafted correctly and we've got the right provisions in there that triggers the buy-sell, and we know how it's funded, typically we use life insurance to fund it. You can have a well-drafted buy-sell, but if there's no way to buy the shares, then it's not really operational. So how we got it funded? Usually companies will fund that with life insurance. And obviously if the triggering event is death, then it's there. But there has to be a mechanism for funding that buy-sell. What if divorce occurs? This gets into some additional succession planning after an inheritance has been received. What's the role of that buy-sell agreement? A whole bunch of issues that come up with succession planning when there is divorce, and how would that business be impacted? Now, real quickly, let me share with you some numbers on long-term care. If you don't think long-term care issues can create problems with respect to business succession, think again. This is a long-term care cost study that was put out by Prudential in 2010. It's some of the most recent stuff I can find on this. Also, University of Minnesota Extension has done a good job with respect to these numbers. But within 20 years, what they're saying is 20% of the population will be 65 and older. In ag, do you think that 20% in the next 20 years, do you think that 20% of the ag population will be 65 and older? Is it more or less than 20%? I think it's more. In ag, you're already over 20%. Okay? Yeah. Okay, look at the costs. These are the current costs. Home health aid on a yearly basis, 44 to 68K. Assisted living, anywhere from 30 to 110. Yeah, it does matter where you're at in the country. And in Kansas and in the rural areas, it's some of the lowest cost in the nation. Nursing home, you can see the cost there. Private room, 70 to 102,000. Semi-private room, 61 to 90,000. If you don't have a mechanism to fund that, you're going to end up in asset liquidation, periodic asset liquidation to fund this over a period of time. And now you've got a couple of liens out there that the state can assert to come back in at death, swoop into the estate and collect any payments that were made under Medicaid while the individual was alive. So if you did spend down and now you don't have much assets, you started on public assistance, then they can have a lien in the estate to clean up after the fact and take that away from beneficiaries. So those lien statutes are pretty important too. Medicaid has financed 49% of long-term care spending back in 2000. 19%. Out of pocket was 19%, which was $37 billion. Long-term care insurance accounted for 7%. We've got to see this number go up. How many of you have long-term care policies? That's good. That's good. You need to shop those things around. There are a handful, some of the companies since Obamacare have moved out of the market. They just quit. So the choices are getting less, but there are ways to tailor these things. There are only about 6 to 8 million people with policies. The average premium was $22.83 according to one of these studies in May of 2013. And that's this study right here, AARP Public Policy Institute. $22.83 was the average premium. And there are various ways to, you need to visit with the insurance companies as to the proper way to tailor those things. But that's really, I think, where the Congress is pushing us with respect to the rules. They want this covered by long-term care insurance. 60% of people rely on family caregivers for long-term care. Estimated value of the care is $450 billion. 46% of people die with no assets, often because of inadequate resources for health issues and long-term care needs, according to AARP. Now, you can take that with a grain of salt if you want. Sometimes, yeah, I don't know. That's just what we can find. That's what they say. I don't know whether that's actually true or not, but that's what they're saying. That seems high to me, but nevertheless, that's what their study showed. There are some planning tools that you can do and utilize in terms of asset transfers. You know, transfer assets to family members far enough in advance, and you're looking at a 5-year window here. That's the basic rule now, and I have an elder law page on our website that kind of goes through all this and gives you the numbers that you need to know. But that look-back period is 5 years. If you transfer assets within 5 years of making a Medicaid application, then they're going to take the value of those asset transfers and count them as available to you. And so that's what I mean by a 5-year look-back window. Watch these penalties that apply if you make transfers within that window. Medicaid eligibility, I know you can't see this unless you're very close to the screen, but basically what this is saying is you've got to have very few levels of resources and income at the time in order to become eligible for Medicaid. And then certain assets are deemed to be available to you. Some assets are excludable. These would be your exempt assets, such as a vehicle up to a certain value and irrevocable prepaid burial expense, prepaid burials, but it's pretty limited. But the following documents should be completed also before capacity issues arise. This is part of long-term care planning. Make sure you've got a durable power of attorney in place, healthcare power of attorney, living will, perhaps in addition to the healthcare power. These powers of attorney is a document in which you designate somebody else to make decisions on your behalf. Okay? A living will is a declaration of your intent. I much prefer a healthcare power, for example, over a living will. Long-term care insurance, we mentioned that a little bit ago. You've just got a lot of things to think about with respect to that. Okay, I'll skip past some of that. Those are the rule changes under the Deficit Reduction Act back in 2005. But generally what you want to do is get nursing home insurance at about age 60 to 65, not beyond age 70 because the premiums are too high. Get what you need and no more. What you need right now is at least 5 years of coverage. If you end up in a nursing home, your look-back period's 5 years, so if you have nursing home insurance, you could transfer your assets, have your private pay for 5 years, and then you're beyond the look-back period. So you want a 5-year policy. And if you can get a 5-year policy where there's no payments for the first 6 months, that'll cause your premiums to go down significantly. Because the actuaries that do these things with respect to long-term care policies know that the data shows that a lot of people don't last longer than 6 months in a nursing home. Okay, some do. My mother lasted almost 5 years, lived almost 5 years in a nursing home. She had a 5-year policy because I had convinced her to do that. Now, that's a problem I had to overcome as the youngest of 6 kids. You don't get listened to by a parent, but I convinced her finally, you know, maybe he does know something about this. I've got this ag law treatise that I wrote a number of years ago, about 17 years ago. I'm in the 34th release of that now. And I gave Mom the very first edition that came off when we printed it, and took it back and gave it to her at the farm home in Indiana, and we get back about once or twice a year. And I remember one of the first times we went back, I noticed that book was blocking one of the bedroom doors open upstairs. And I said, and it had the stack of releases on top of it, the second edition, third edition. She just stacked them on top. I said, how come you haven't put your releases in the book? Well, I don't read that. That's too big of a book. Why would I read that? But it's a perfect doorstop. So I get no respect at all. But at least she did listen on this one. Get what you need, no more. You can get a rider to increase policy benefits as time passes. Determine what your income is from Social Security, rents, and dividends. So that's what you always want to do. What do I have currently coming in? And break it down on a monthly basis. If it's going to cost me $6,000 a month in a nursing home, do I have enough currently on my rental income, Social Security benefits, retirement, pension, royalties, oil and gas income, those types of things? What does that add up to? Then figure out what your shortfall is if there is one. And that's what you have to plug with insurance. Okay. Or what you would anticipate that income's going to be. And then you may want to get lifetime coverage. Some people just want lifetime coverage. Recommend it, but there are some other options if you're too old to get insurance at a cost-effective on a cost-effective basis.
Question.
Yeah.
Would it be possible to have some sort of a contract or agreement with that person, that child in your family that wants to continue the farm operation, to pay your long-term care while you are in a facility,
Yeah.
in exchange for that land?
Yeah, it's possible. The question was, can I have an agreement with the child that's going to run the farming business to pay for my long-term care while I'm in a nursing home in exchange for receiving various assets? Yeah, it's possible. Is that suggested? I don't like it because, one, you definitely would want to get something like that in writing because they could walk away from it. I don't prefer that approach. I much prefer having a long-term care policy that covers this and then just going ahead and transferring assets outside the 5-year window, having the insurance coverage be my backstop and go ahead and move those assets, basically doing my estate planning not at death but before, and having the insurance policy cover. That would be my suggested approach. Can you do that? Yeah, but that's going to require careful drafting of an agreement to make sure that that's a binding agreement and they can't walk from that. That's the concern I would have. Okay? That's the lien issue and some various strategies that are mentioned there. But let me just ask you the question here. Let's say we've got an individual that has $800,000 of farm assets, $100,000 of non-farm assets, $900,000 total assets. Income from Social Security is $15,000, rent's $30,000. They have 3 kids, 1 child is farming. Based on those numbers, are the farm assets and the son's vocation at risk if the individual ends up in the nursing home? Absolutely. Yeah, absolutely. That's a problem. And if you don't have a plan in place to satisfy that, you've got problems long term. Role of insurance?
Basically, all it says that at death, let's say you've got $2,000 a month you're paying for long-term care, and you pass away before you go to a nursing home, that they pay those assets back to your estate, like an insurance policy.
Yes.
Okay.
Yeah.
Is it an additional rider to the...
Typically.
Okay.
Yeah.
Usually what percent?
I don't know. I do know it exists.
Is that a good thing to have?
It depends on each situation. Again, that's one of those one-size-fits-all, no. It's just going to depend on your individual situation. Probably for somebody with a smaller estate, I might be able to make the argument that that works. It's kind of like these reverse mortgages, which I don't like as a matter of thumb. I don't like those, and the reason I don't like them is because the kids and the parents may have misconceptions as to what things are going to look like after the parents are gone. You don't own the house. The bank owns the house. And they tend not to understand that. You see these commercials on TV, and I think it's a former senator that's even promoting these. And it's like, Fred, okay, I understand the concept here, but make sure that the people understand the concept. There is no asset left. when you're gone. Yeah, it gives you income, but then the kids don't have an asset. And the kids tend not to understand that. I think if everybody has full disclosure, then I can accept it. I kind of view this the same way. If there's full disclosure, okay, but there may be some misconceptions about it. But life insurance, that is a key component in succession planning and transition planning. Funding a buyout is big. Equitable distribution among the heirs, I've emphasized that today. Paying debt off at the parent's generation at death, not saddling the next generation with debt. Now, we're much better now than we were 30 years ago with respect to that issue, and then paying estate settlement costs. Providing liquidity at death, insurance can be very helpful with respect to that. Farmers and ranchers may have a lot of high dollar assets, but maybe have trouble with liquidity, and so that's an issue that's out there. Okay, income during retirement years, it can come from all these sources. Again, under Obamacare, you've got the passive 3.8% tax on passive sources of income, and that hits retirees disproportionately hard once you get over the $250,000 threshold. But a lot of it is individualized in terms of successful transition planning and having a person that can actually take over the business as the prior generation has, and developing an exit plan and identifying the next leader and dealing with outside advisors. Again, you got to use a team approach here, and these would be the people that would make up your transition team: accountant, attorney, business consultants, counselors, financial planners, insurance agents, lenders, mediators, other respected business persons. All of them. They all have unique characteristics they can bring to the table, and form an advisory committee. And again, when I say bare your soul, let the people know, figure out what your goals and objectives are, and make sure that your advisors know what your objectives are. Being able to articulate them is absolutely critical. Maybe form a board. It's an investment, not just a cost. This is what our friend in Missouri couldn't understand. What he was investing in, or should have been investing in, was his family. I mean, that guy didn't even have a will. And he had over $26 million in net worth. I mean, this is not just a cost, and that's what he was looking at it as. Well, it's going to cost me $175,000 to do this. No, it's an investment. You're going to end up saving your family a bunch of grief and about $12 to $12.5 million of taxes. And for crying out loud, you got terminal cancer. What are you thinking? And I could not convince him. I've never been so disappointed in anything other than that. Unbelievable. Okay, and then executing the plan. Now let's go to, in concluding here, let's go to this other document, Common Estate Planning Mistakes. These are the things to avoid, and some of these should be intuitive. But it's amazing, and I'll leave my contact information, and Christine's up there. She's my staff attorney. It's just amazing to me how some of these are missed. Too much property owned in joint tenancy or too little property owned in joint tenancy. Now, depending on the size of your estate, that's a tax issue is what I'm driving at there. Once you get into a potentially taxable situation, federal estate tax-wise, you don't want to have jointly held property. Sever those joint tenancies. Own them as tenants in common, so that then you can control passage of the property under the terms of your will. The will doesn't control passage of jointly held property, and that can create income tax issues later on. But joint tenancy for small estates is fine. So that's why I say too little of it owned in joint tenancy if it's a small estate, a non-taxable estate. That's fine. So for the vast majority of people, it's fine, but once you get up substantial values where it's potentially estate tax issues, then you got to get rid of joint tenancy. Sever the joint tenancies. Making the plan too complex. Okay, I was in Los Angeles not too long ago. Unfortunately, I end up in these warm places in the summertime. My son gets out there in the wintertime, and something's wrong with that. I end up staying home in the wintertime and going to the warm places in the summer, which doesn't make a whole lot of sense. But when I was in Los Angeles, there was an attorney. I was doing an all-day conference for Southern California Bar Association, and a lawyer came up to me and wanted me to look at his will. It was a two-day conference. Said, "Can you look at this tonight?" Oh, yeah, sure. I don't have anything else to do tonight. I'd like to look at your will. That's not what I said to him. I said, "Sure, yeah." 72 pages. His will. After after about the first 10 pages, the next 62 were gobbledygook, not necessary. And he asked me, do you think it's too complex? Yeah. I think you could do what he needed to do in 10 pages, and the rest of it, they had just done too much entity planning, too much structuring, and it was too complex, and he didn't understand it, and my head was swimming too. I said, this is way too complex. You don't need all this. After I visited with him and figured out what he needed. I don't know if he got it redone or not. The failure to review the plan, we talked about that earlier, update it if there's significant law changes or changes in your life. Failure to check titles to property, that's a big one. Make sure you know how property is titled and in whose name it's titled. It's amazing to me how we screw that up. It's also amazing to me how many times I see practitioners draft wills and trusts just based on an assumption that the client told them that property, real estate was titled a certain way. Well, did you go to the courthouse and check? No. Do it. Yeah, make sure you know. Get actual copies of the deeds. From the lawyers need to do this. Get copies of the deeds so you can read what the title ownership says. Don't assume anything. Failure to balance property ownership in larger estates, so that's again going back to the joint tenancy issue. Failure to check the beneficiaries. Make sure the beneficiaries dovetail with what your overall plan is on life insurance in particular, other assets that have a beneficiary designation. Okay, simply doing nothing, number 10, is procrastination. Incorrect ownership of life insurance at number 12. Not being able to find the will, number 13. That should not happen. Does everybody know where your will is at? Anybody not know where your will is at? And he admitted it. Well, that's honest. Yeah. Equal fair issue at number 15, we talked about that. Failure to plan to have sufficient liquidity at death, that's an insurance issue, largely. Number 19 and 20, making gifts to children without clarification in the will, or making loans to children without clarification in the will. What's happening there? Multiple kids, assets going equally to the kids, and either gifts or loans have been made to some of the kids in advance, and now you got unequal distribution because some have been made. They claim, well, that wasn't a gift, that was a loan, or it was a loan, it was not a gift, and we don't have clear specification in the will, and you get the kids fighting. Nice. Okay, so clearly specify the reason for the imbalance is I gave, if this is a loan, it has to be repaid back, or it was a gift, I've already given them property, that doesn't have to be paid back, that's why they're getting less now. Okay, just be clear on that. Not maintaining good records, number 23. Not having a well-drafted buy-sell, number 24. Read the Bauer case. Yes. 21. Discussing the estate plan with children. Generally, don't do that. Now, the exception would be for farming operations. If it's a family business, you got to get everybody in. So that's why I put in parentheses, unless a family business and its succession within the family is involved. Otherwise, it's none of their business. Okay?
These wills, they have to be probated?
Wills do have to be probated, yes, to be effective. Trust, no. You can avoid probate if you got your property fully funded into a trust. Yeah. But wills, to have any effect, have to go through probate. But again, back on this issue, it's none of the kids' business unless they're involved in the business. Then, yeah, they need to know the whole plan. Otherwise, no. They don't need to find out that they've been disinherited until you're gone.
You need to know where the will is.
They need to know where the will is, sure, yeah. Whoever the executor is going to be needs to know where to find it, yeah. But otherwise, in terms of what the plan, what the disposition of the assets is, Well, I would still say no unless a business is involved and they're all involved in the business. I would, my view is that I will decide, I will make it equal and fair. They don't have any input on that. Okay, you're back to the business issue, and that's where I want everybody involved. If I'm not talking a business, and it's just me, I don't have a farming business, it's just I'm a salaried employee, and the kids aren't involved in what I do, then no, it's none of their business how I'm sending my assets. Yes, that's what I'm saying here in the parentheses, unless a family business and its succession within the family is involved. That's the exception. Yeah.
We know that a person had a will or divided, I think, among whoever. But in the will, it says no probation.
Well, that probably means, and that's not going to work if he had a will. A will is not effective unless it's been admitted into probate.
But the other things were not to be probated.
There are some assets that are not probate assets, such as life insurance and jointly held property and all of that. That's not subject to probate. Yeah. Okay. Flip to the back side. Not keeping beneficiary designations up to date. I just put this one in because there was a case I read about a year and a half ago. Unbelievable case. Dad dies, has a significant amount of life insurance. It's 7 figures that's going to pay out. And he forgot to change the beneficiary designation from his girlfriend to his wife. And the wife had never heard of the girlfriend. Yeah, that was not happy. She was not happy. She sued the insurance company because they refused to pay her. And they said, look, you're not the beneficiary. What do you mean I'm not the beneficiary? She is. Who's she? Don't know. You better ask around. It was his girlfriend. Oops. So you ladies better check this afternoon when you get home. Okay? Yeah. So what are the most critical estate planning documents for most people? The will, this is the way I see it, will, power of attorney, and the revocable living trust. Okay? So some things to think about. I know there's a lot of stuff we talked about today. Yeah. Yeah, good question. Her question was, on a revocable living trust, do I want one joint trust that covers both spouses, or do I want one for each spouse? You can go either way on that. My personal preference is one for each spouse, simply because I think it's easier from a tax planning standpoint. It's easier for IRS to understand these. It's easier for FSA to understand a separate trust. And we can get a separate ID number for each trust if we need to. If there's one, it can raise some administrative issues. There's some issues that come up with respect to expense method depreciation, for example, that I can think of. There's some other issues that just raise questions, whether they're issues or not. I think it's administratively simpler to have 2, one for each of them, and just keep them separate. Yes?
Does a revocable trust carry the same security from health care taking the assets that are...
Yeah, revocable trust with respect to health care and Medicaid expenses is not going to get you anywhere. It has to be an irrevocable trust. Yeah, because if it's revocable, what that means is those assets still belong to you because you retain the right to revoke the trust up until the point you die. And so that's what we call a grantor trust. And all the income flows through that trust back to you. It's just like you owning the trust. So there's no difference there. From an asset protection standpoint, it has to be irrevocable. It has to be an irrevocable trust.
Does that take 5 years before?
Yeah, we would want to create the trust more than at least 5 years before any application for Medicaid is made. Yep. Back here. Okay. Okay, in that, for a Medicaid trust, for an asset protection trust, you don't want the grantor to be the trustee. You want somebody else to be the trustee.
So if the original grantor is the food, and the successor grantee is the successor trustee,
As long as that's not the grantor, yes.
Right.
Yeah. But to have any type of asset protection, I cannot have the same person that created the trust be the trustee. It's got to be an independent person. Yeah, and you've got to have what we call spendthrift provisions in the trust. Okay? Excuse me? No, her question was if you have a trust, do you have to have a will? The answer technically is no. You could have a trust, and you could have what's called a pour-over will, which would be the suggestion that says that if I leave anything out of my trust at my death, pour those assets over into my trust. So just make sure I got everything in there. That's not a full-blown will. It's just a pour-over will that says dump anything else I forgot or that I didn't title into the trust. Just dump it in there. But the answer is no, you don't have to have both. You can also have a trust that's created as part of a will. That's called a testamentary trust. So the living trust stands alone. The testamentary trust is created by the terms of the will. If I've got a standalone revocable trust, for example, I want to have a pour-over will that dumps all the other assets that I might not have gotten titled in my trust. It just instructs the executor at the time of my death, put those in the trust so that I don't have a probate. Yes. Yeah, you could keep whatever assets out you want and transfer them into an entity separate from the trust. Yeah. There's a lot of flexibility in estate and business planning and succession planning. That's one of the things that you can do.
Then would that go to probate?
Well, anything that's not in the trust that's included in decedent's estate is potentially subject to probate. Yeah, the membership interest is what's included in the estate, not the assets in the entity. It would be the membership interest that's held by that individual. Okay. I saw another hand. Was it over here? Yeah, the idea of the pour-over is to eliminate probate by virtue of getting all the assets into the trust so that we don't have anything hanging out here that requires a probate. That's the whole purpose of that.
Well, would you go over that one lady's question about a will or trust?
Revocable trust?
And did she say nursing home?
Nursing home.
Care? What was her question?
Yeah, it's basically, can I protect assets, if I understood the question right, by using a revocable trust? And the answer is no, because those assets, since it is a revocable trust, are still deemed to be owned by you individually, and they're reachable, because you can revoke the trust at any moment before death. So in order to protect the assets from creditors, it has to be an irrevocable trust of which the grantor is not the trustee, and it has to have special provisions in it saying, I'm not entitled to distributions from this trust other than at the complete discretion of the trustee. So I can have no control over distributions, which means I don't have any property. I've divested myself of that property, but it has to be irrevocable to get you there.
Is there an approximate dollar value? Should put it in a trust versus letting it go through?
Hey, that's a great question. His question was, is there an approximate dollar value as to when you would want to use a trust as opposed to probate? There comes a point in time at a cutoff, and I'd say, once you've got to be at least six figures to justify the extra cost of a trust. I mean, if we're talking a $50,000 estate, maybe even as much as a $250,000 estate, I would probably not suggest somebody a trust unless they want privacy or unless they want additional creditor protection. But in the smaller estates, that's typically not an issue unless somebody puts a high priority on privacy. I mean, we could go, what is this, Reno County? Are we in Reno County? We could go down to the courthouse in Reno County and read wills today if we wanted to and see who people left their property to. If you've never done that, do that occasionally. I do that once every 5 or 6 years. It's just kind of fun. And we used to have the little town that I started practicing. Well, I was in North Platte, but we lived 30 miles north of North Platte in a little town of 298 people, and they were so happy when my wife and I and our daughter at that time moved in. They actually spray painted a line through the 298 and wrote 301 on the sign. It was incredible. But there were two little ladies in that town. They had a weekly newspaper. And when somebody died, they'd go to the courthouse as soon as the wills were probated, and they would republish the contents of the will in the paper.
Oh my God.
And I was also county attorney, and people in the town literally beat my door down What can you do to this? It's not a crime. They can do this. It's a public document. But they're publishing it in the paper. They can do whatever they want with it. I mean, at least they didn't have the internet at that point in time, or they'd have put it all over the internet. But this was right after the section of so-and-so had Sunday dinner at so-and-so's house. Then the will. And it did drive people nuts. Now, I tell you what I told them. I said, now, I got an office in North Platte. And we can draft trust, and trusts are not a public document. The only thing they're going to find when somebody dies, if you got a trust, is they're going to find filed records. This person had a trust, and here's a certificate of trust existence. And that's all they get. They don't get any of the dispositive terms. And that's going to shut their little business down. And so I had trust business running out my ears from people in town that wanted trust. So, and I would say at least 6 figures of an estate size, because a lot of time, your probate fee is going to be based on the size of the estate. And really, the trust becomes more cost effective once you get larger, unless you've got a high priority on privacy, and then that trumps everything. So that's how I would answer that. But literally, these ladies would publish contents of wills, and it would just drive people up a wall. And they were the sweetest 2 ladies that you would ever want to meet, but they just created a firestorm by doing that.
By the same token, it's just like the county, that person can put a POD on it.
Yeah, in Kansas, you've got a transfer on death or payable on death. Yeah, you got a TOD statute, you got a payable on death for bank accounts. That's beautiful, too. That avoids probate. Okay. Okay, I think we're way past time. I'll be glad to stay as you have questions, but thanks for your attention today. I do appreciate it, and thanks to People's Bank and the Extension Service that hosted the meeting too. Thank you. Cody?